Hello, my name is Nicolette Sambus. I represent Mr. Jones with regards to his workers' compensation case and this pending appeal. I'd like to reserve 5 minutes, if I may, for rebuttal.
Okay.
May it please the court. This is a case where it's a de novo standard of review. It doesn't seem like that's being disagreed to by the appellee in this case, where it's a matter of law. The issue is whether the judge of compensation claims erred by denying the claimant his request for authorization of an evaluation with a qualified physician for medical marijuana. It really comes down to the fact that the judge skipped that step, skipped the step of authorization of an evaluation with a qualified physician, and just determined that because it's medical marijuana and because he interpreted Florida statute section 381.986 to say that it's barred under 440, that he can't get the evaluation.
So may I ask about the mootness or the redundancy finding of the JCC? Since Dr. Gordon has already evaluated claimant for the purposes of medical marijuana, why isn't this case moot?
It's not moot for several reasons. A, in practice and even in application, an IME is not the same as an authorized treating provider. So the employer carrier is responsible for providing reasonable medically necessary care that is causally related to the industrial accident, and that goes from an authorized treating provider. The claimant in this case got an IME to prove his case, to prove that it's reasonable medically necessary causally related to the industrial accident. They're not the same. There's the Tomokovich versus LaPointe case, which is 904 Southern 2nd 538. That's a 2005 decision from this court, and it talks about that although an IME may ultimately assist the claimant in securing benefits that are medically necessary, it's not in and itself treatment. This court has gone through many cases that talks about the difference between furnishing and authorizing medical care. They're not the same. It's the employer carrier's responsibility to furnish medical care. That's what it says in the statute. That's what 44009 says. It has to furnish medical care, and that's what the claimant was asking for, authorization of an evaluation. And that's just one step. So according to the medical marijuana statute, you don't just go to the doctor once, you get your card, and then you're done. You never see the doctor again. You have to go once at least every 30 weeks. You get a 35-day prescription, or it's not even a prescription, however the statute defines it. You get 35 days, but you have to go back for that recertification every 30 weeks. So the fact that the claimant has an IME that proved his case is no different than an example where the claimant asks for authorization of a primary care physician and has to obtain medical evidence because the claimant's burden of proof to present it to the judge of compensation claims that it's reasonable, medically necessary, causally related to the industrial accident. And that's what this case is. All those three requirements: reasonable, medically necessary, causally related to industrial accident, uncontroverted, undisputed, but the claimant still had to present that evidence. So it gets an IME, but an IME, employer carrier is not bound by any decision that an IME has. You still have to present that to the judge of compensation.
But doesn't that presuppose that the treatment is going to be compensable at the end of the day? The medical marijuana, in this case, will be reimbursable at the end of the day?
Well, it doesn't presuppose it, because what if the evaluating physician determines that the claimant in this case is not a qualified candidate? I mean, there are requirements. It's not I can go and get my card no matter what I have. You have to meet those qualifications. You have to be a qualified patient, and a qualified physician has to make that determination. In this case, the claimant, it is as applied to the claimant is a candidate for it. Yes, he has one kidney. He is on has chronic intractable low back pain from a 2001 industrial accident. He is having side effects from the opioid medication. There is an opioid crisis that goes on, and he is concerned about the chronic use of the medication from a 2001 industrial accident. We're sitting in 2020. This accident's been going on for 19 years.
Well, let's take a step back. This is a referral case, correct, under 44013 3D?
3D.
Correct?
Yeah,
Right.
yeah, he's asking for he got a referral from an authorized treating provider, Dr. Hunkalata.
Right, so this is not a one-time change case, this is a referral case, correct?
Correct,
Okay,
yes.
so, and under the exception to that, the JCC may, deny that referral if the procedure is not medically necessary, correct?
That's correct.
Right, so isn't this case about medical necessity? Isn't that the central question here?
Well, no, the central question, I mean, the judge answered that it is medically necessary.
Well, the federal law answers it a different way, though, doesn't it? The fact, I mean, do you know what the definition of Schedule I controlled substances under the Controlled Substances Act?
Yes, I understand that medical marijuana under the Controlled Substance Acts from 1970. I mean, the Controlled Substance Act got passed in 1970, and it talks about medical, or marijuana, not medical marijuana, but marijuana is a Schedule I. Yes, so it's
All marijuana.
all marijuana,
Right.
right. But there's a new case that came out from the Superior Court of New Jersey that addresses the Controlled Substance Act versus this, like, the individual state. In that case, it was New Jersey, which is substantially similar to what we have here. And I don't know if this court has seen it. It came out a couple months ago. It's Hager versus M&K Construction. I can provide that to this court if you request it. In that case, it talks about it is not a conflict with the federal law. Since 2004, it's been clear that the 2014 congressional appropriation riders have prohibited the use of the Department of Justice funds that prevent states from medical marijuana programs from implementing their state medical marijuana laws. And that's United States versus Kleinman.
That's an enforcement aspect. Do you agree, though, that despite its age, I mean, yes, it's 40 years old,
Right.
or 50 years old, it's still a law, right? It hasn't been repealed?
That's correct.
Okay, and it's still a Schedule I substance, marijuana.
It is, but it's legal.
In fact, just a few years ago, the DEA refused another petition to reschedule marijuana. Do you agree with that?
I do agree.
Okay, so just a few years ago, the federal government has once again said that marijuana still doesn't have any medical use and still is a risk to the health. Do you agree with that?
That's what the federal government is saying, but they're not enforcing it on the state level. The state of Florida and its constituents have passed this medical marijuana law. We have Article 10 and Section 29 that has legalized, decriminalized marijuana for the use of qualified patients from qualified physicians. So,
Well,
yes.
what it really does is provide immunity from civil and criminal liability under state law for the possession and use of marijuana under certain circumstances. It
Yes.
doesn't decriminalize marijuana.
Well, I would say that in Florida, as long as it's under the medical marijuana statute and you have the card and you've got it by authorized means, you're not a criminal if you're in possession of it.
Well, let's just stick with the definition of medical necessity under 440.13.1K. Widely accepted, based on scientific criteria, determined to be reasonably safe. Doesn't that expressly conflict with the federal definition that there is no reasonable medical use for marijuana? Why isn't that a conflict?
It's not a conflict because the Chapter 440 addresses reasonable and medically necessary care. It must be within the practices, parameters, and protocols of the locale where you're located, right? So the state of Florida here, we're not operating in the federal government stance, although the state of Florida is, yes, I agree that the federal government is the top priority and then the state, but it is, the judge of compensation claims has already determined that it was reasonable and medically necessary based on it being within the practice, parameters, and protocols, and it wasn't disputed by the employer carrier, and even in their answer brief, that it is reasonable and medically necessary. They stated several times in their answer brief that it's reasonable and medically necessary. That's a question of fact that was determined by the judge of compensation claims and is not even being disputed. So if you have a medically necessary evaluation with a qualified physician, and I think that, yes, these questions are relevant to the ultimate process that this takes. The first step is authorization of a qualified physician to evaluate the patient. The patient hasn't gotten that. The injured worker hasn't gotten the evaluation with an authorized treating provider.
I was trying to think about this in other contexts. Can you give me an example of another context in a workers' comp law where the employer has been on the hook for an evaluation, but we know from the outset that the ultimate treatment is illegal under Florida law.
Well, the ultimate treatment isn't illegal under Florida law.
Well, it's not reimbursable under Florida law.
And
See-
it's illegal under federal law.
Well, it's not, the statute says marijuana, the specific section that you're referring to, 381-986-15, says, quote, "Marijuana as defined in this section is not reimbursable under Chapter 440." So that's marijuana. That's not an evaluation with a treating physician. Now,
No, I understand that distinction, but my point is, give me another example where a case where we have authorized the evaluation for a treatment that we know the employer is not ultimately going to be on the hook for under Florida law with absent a constitutional challenge.
well, you could go chiropractic care, or you could go acupuncture. Those are, it comes down to the claimant and the employer carrier even's ability to be educated, right? So this ruling from the judge has taken that decision away. The cost-benefit analysis, the education that either the injured worker can make that decision, he can go to a qualified physician if this was authorized, he gets evaluated, and then he gets told, yes, you qualify for medical marijuana. Then he could make that decision if he's going to use his self-pay and pay for the marijuana, but the employer carrier pays for the evaluation with the physician because that's not barred under the statute. And that's the same as chiropractic care. If a
But
physician,
the federal law prevents physicians from writing prescriptions for marijuana, does it not?
it does, and so does the Florida
Right.
state law.
So-
It's not
so-
necessarily.
So let's be clear that in your, in the pretrial stipulation, the request is specifically authorization for a referral for medical marijuana. And that's what the prescription is written for, correct?
The prescription says authorization, it says another physician who can prescribe him, and it's marijuana. That's what the prescription attached to the petition for benefits, so it's in the
So that's
record.
my point. So an authorization for a physician to commit an illegal act under
can-
federal law, to write a prescription for marijuana.
Well, the word prescription, I think, can be confusing because physicians are allowed in the state of Florida, if you're a qualified physician, to evaluate and then submit your name to a registry. So it's not necessarily that they're writing a prescription, and the Florida state law has made that clear. And in Dr. Gordon's testimony, he says that he's not writing a prescription because that's not allowed under the state law. He's doing what he's supposed to do as a qualified physician. And so that's the case here, is that the claimant was asking for that evaluation with a qualified physician. Yes, it deals with medical marijuana, and I understand that. But the Article 10 talks about no health insurance provider is to be responsible for medical marijuana. Well, workers' comp is not a health insurance provider. And so the New Jersey case talks about that as well, that workers' comp is specifically excluded as a health insurance provider, and that's in Florida Statute 624.603.
Well, let me take a step back. Let's not get lost in the semantics of
Sorry.
prescription. Could a physician perform the acts that are being requested under this referral under federal law?
I believe yes. That it happens, this is what's happening. That's why the Florida Constitution has been amended to allow.
Well, I think let's not conflate a decision not to prosecute with, I think her question is it legal under federal law?
Still believe that it is, the decision not to prosecute versus it being legal under federal law, I believe is also an issue of semantics. This is occurring. These physicians are providing the evaluating patients and determining whether they're qualified patients. So that is going the step beyond of what is actually being asked for here with the claimant. The claimant is simply asking for an evaluation. You're asking me, is it illegal, or is it illegal for the physician to do that? But that's not the issue that's before this court.
What if the referral instead were, the doctor says, I've tried all this treatment for this patient. I want to refer him to a doctor to evaluate whether heroin might work. We don't know if it'll work or not. It's an evaluation. It's a referral from a treating physician. Would that be acceptable? Is that compensable?
I would say no.
Why?
That's taking it to the extreme. Then that's not the issue that's before the court.
Why is it extreme? It's another Schedule I substance.
It's not legal in the state of Florida. In the state of Florida, which is why we're here, it is not a legal substance. Heroin has not been part of public policy where the state constituents and has passed this law that has made it and 33 other states have also allowed it to be legal for medical marijuana. Heroin is different than
What
medical
happens when
marijuana.
there's a conflict between the state and the federal law?
So you're supposed to go through the analysis. The first step is whether the federal law is a valid exercise of power. That's not challenged here, right? Then the second step is whether the state law stands as an obstacle to the accomplishment of the federal objective. I'm quoting from the Armstrong decision of the United States Supreme Court. And so here, the state and federal laws, as interpreted, are not conflicting. So then you go to the third step, which is conflict preemption applies when it is impossible for a private party to comply with both the state and federal requirements.
So why isn't there a conflict with ordering an EC to provide medically necessary services or prescriptions or access to prescriptions, and the federal law saying marijuana is never medically necessary?
It's that you cannot commit a crime that's already been accomplished, right? So if the claimant is just getting an evaluation with a qualified physician, there's no crime there. If the claimant gets his medical marijuana from his card that he gets from the qualified physician, he gets his medical marijuana, he's got the marijuana in his possession. If the employer if the employer carrier reimburses the claimant, it's already for a completed crime. So you can't, there's no federal law to complete a crime. You can't prosecute for a completed
The
crime.
conflict, though, is, so focusing on the term medically necessary, and not talking about whether marijuana is possession of as a crime. We're talking about the evaluation. And first, you would agree, I think, that this was a specific referral under 381-986 subsection 4 for physician certification, so potentially physician certification so that the employee could get on the registry for marijuana. Do you agree with that?
Potential, it's an evaluation.
Sure, but it is an evaluation specifically under that statute. That is the purpose. It's not a second opinion on how to manage his pain. It wasn't a general referral. It was specific referral because the referring physician was not on the registry or qualified to provide that physician certification. Is that right?
We don't even know that, though. I mean, yes, the purpose of the statute was the purpose of Dr. Hunkalata making this recommendation was for investigating medical marijuana, but
To determine whether he can certify him so that he can get on the marijuana registry.
this other physician could have came up with other options. It's another
But that's
physician.
not the referral, though. It was a specific referral for marijuana. Do you agree with that?
Yes.
That's what the petition said.
Yes, Your
It
Honor.
said marijuana.
Yes, Your Honor.
Okay, so if 381-986 didn't even exist, Article 10, Section 29 didn't exist, would we be here? Would this be a claim?
If the judge of compensation claims denied it, I would certainly appeal it, and I'd certainly be here.
And your argument then would be what? That it's still reasonably medically necessary, even without 381-986?
Okay, I misunderstood your question. So you're saying if it was illegal, and the Florida statute, the Florida amendment to the Constitution had never been in place?
Sure.
Oh, like the heroin.
Yes.
I don't think I would be here.
Okay.
Okay.
And I just, what is that, I guess, so your distinction, you're relying on state law as the basis for this being reasonably medically necessary, notwithstanding what federal law says to the contrary.
Yes, I believe the state law is in place for a reason, and and this court has upheld this state law on numerous decisions, specifically the first DCA. I see that I've gone over my time, but I request you reverse the JCC's.
That's fine. Madam Clerk, please extend her time by 8 minutes, and of course, do the same for the Appellee's Counsel's time.
Good afternoon, Chief Judge Ray, Judge Rowe, Judge Tannenbaum. My name is Mary Cruikshank, and I'm before the court this afternoon on behalf of Appellee, the employer in this case, Grace Healthcare. The JCC's decision to deny the claimant's request for an evaluation to assess whether he was a candidate for medical marijuana should be affirmed by this court. Any other decision would be in contradiction of the Florida Constitution state statute, and run afoul of federal law. As a preliminary matter, Your Honor, I would like to hopefully quickly dispense with one of the arguments that has been made by the appellant, at least in the briefs and at least touched on here today, and that is the claimant's argument that Judge Massey either ruled on the wrong issue or ruled on an issue that was outside the scope of the issues presented for hearing. Judge Massey did neither, although Judge Massey did have some difficulty ascertaining what the issue was at the final hearing. After great care, he finally elicited what he understood to be the issue on appeal, and that was the claimant's request, not necessarily for medical marijuana, but for an evaluation to assess whether he was a viable candidate for medical marijuana. Judge Massey, after a studied review and analysis of both federal and state laws, properly determined that the claimant was not entitled to even an evaluation to assess his candidacy for medical marijuana. But whether the issue was a request for an evaluation, reimbursement of the evaluation that was already done, as you noted, Judge Ray, or medical marijuana itself, the result would have been the same. None of the above are compensable or reimbursable under Chapter 440, the workers' compensation provisions.
The JCC cited a conflict with federal law, but what portion of the CSA is violated by a referral for an evaluation?
Well, first of all, Your Honor, I would direct the court to the Florida Constitutional Amendment itself, and within that section, Article 10, Section 29, subsection C7, it indicates that nothing shall require any health insurance provider to reimburse any person for the expenses related to medical marijuana. An obvious expense related to medical marijuana is a prerequisite evaluation. If you don't have an evaluation, you don't get the medical marijuana.
And I guess the follow-up to that, though, is the employer in this case a health insurance provider? Certainly not a governmental agency.
Well, certainly, Your Honor, if we look to Section 381.986, subsection 15F, it specifically indicates that medical marijuana is not covered under Chapter 440. So subsumed within that, I would suggest that the evaluation, the medical marijuana, et cetera, would be excluded under workers' compensation. Should Your Honor or Your Honors read Section C7 of Article 10, Section 29 to refer only to traditional health insurance providers, I think that would be a very narrow reading and certainly not consistent with what the state of Florida and the people of this state intended. But there is another constitutional provision within this amendment under the same section, Section C5, which indicates that nothing in this amendment requires the violation, any person or entity to violate federal law, which this would require the employer in this case or a carrier in the workers' compensation setting to violate federal law.
Well, and so that brings to my question.
Back to your question. Thank you, Your Honor.
What provision of the CSA would be violated? But no, I
Correct,
appreciate
yes.
that context.
Right. As we discussed earlier, the Controlled Substances Act of the larger body of law, the Comprehensive Drug Abuse and Prevention Control Act, which was enacted many years ago, but still good law and in effect to this day. At Section 21 U.S.C., Section 841, subsection A1, this prohibits possession and use of a controlled substance such as marijuana. As Judge Tannenbaum, you pointed out earlier, marijuana is still considered a Schedule I drug. It has not been changed. So there is an additional provision within the federal guidelines, 18 U.S.C. subsection 2A, which indicates that anyone, that this provision prohibits anyone from aiding, abetting, or inducing another in the commission of a crime. So for an employer or a carrier to provide an evaluation for the sole and exclusive purpose of determining whether that person would be eligible to use an illegal substance, illegal under federal law, would obviously be tantamount to aiding and abetting the claimant in this case or any other case to committing a crime.
Well, wouldn't that be
And aiding and abetting is a crime.
Wouldn't that be 2 levels removed from the activity? The employer would be required to reimburse the patient or pay for the provider to do a medical evaluation. Maybe the doctor provides a physician certificate under 381-986, which then enables the employee to get on the registry and get marijuana. Where's that connection? How is it that the employer, in reimbursing for a medical evaluation, how is that a violation of the CSA?
Because again, Your Honor, the medical evaluation is a prerequisite to getting medical marijuana. Again, no evaluation, no medical marijuana. It is essentially the employer that would be greasing the rails or facilitating the claimant to ultimately obtain potentially medical marijuana in any case in which an individual were deemed to be a viable candidate for medical marijuana under the Florida Medical Marijuana Program would be necessarily committing a violation of federal law. Now, whether that carrier would be prosecuted matters not. A violation of the law is a violation of the law. Whether there's any substantial risk of prosecution or even being caught, that doesn't matter. That's an irrelevant point.
But embedded in that theory is the premise that you said that the medical certificate, the physician certification would be required before the employee could get the marijuana. But that is relying on a statute that authorizes something that is still federally illegal. So it really isn't that, I mean, the patient could go out or the employee could go out and get the marijuana himself, whether it's with physician certificate or not, it's still a violation of federal law. So I don't understand how it is that sending him to an evaluation, which you were asserting would be required before he could get on the registry, and how that's aiding and abetting a crime any further than if there weren't a statute in the first place.
Well, Your Honor, the way the scheme is set up under the public health provision in Florida statutes under 381.986, an employee or an individual cannot obtain medical marijuana under that scheme without first undergoing the evaluation. And so if an employer or a carrier is deemed required to provide that evaluation as a medically necessary stepping stone, if you will, then that would require the employer carrier to run afoul of federal law. And so that requirement would make Florida Workers' Compensation Statute 440.13 in conflict with federal law. And anytime, as Judge Rowe pointed out, when there's a conflict between state law and federal law, under the Supremacy Clause, the federal law prevails and preempts. And then we would have to look to that provision, which indicates that marijuana is still a Schedule I drug and is illegal. So if it's illegal federally, it is still technically illegal in Florida, even though people have a constitutional right to seek it out.
Sure. Well, let me take you back one step then. Why does your client start out with the position that it is reasonably medically necessary, which itself flies in the face of the federal law that you're asserting is preemptive downrange, but not on the question of whether it's reasonably medically necessary in the first place?
Well, Your Honor, and that was a good point that Judge Rowe brought up earlier, that if it's not deemed to have any medical use under federal law, how could it then be medically necessary at the state level under the Florida Workers' Compensation Act? And Your Honor, this was a decision that was made by Judge Massey, that based on the medical evidence before him, Dr. Gordon indicated that this type of treatment was medically necessary for Mr. Jones, and it was causally related to the accident.
And in the order of the JCC, and I'd like to get to kind of maybe preservation issues as well, that he wrote, although the employer asserted medical necessity as a defense, they presented no meaningful argument or evidence in support of that defense. Is there any requirement in a case like this to preserve that legal argument on medical necessity? What is the impact of the EC not presenting evidence or argument in support of that defense below?
I don't think there's any impact, Your Honor, in this case. And the reason being is that simply because a doctor opines that a form of treatment is medically necessary and even causally related to the accident doesn't necessarily mean that that's a compensable form of treatment. For instance, Judge Tannenbaum, you mentioned the option of heroin or cocaine or any other illegal drug. It would not be compensable even if a doctor opined that it was medically necessary. So I don't think you waive any argument simply because a doctor utters the magic words. In this particular case, Dr. Gordon did indicate that it was medically necessary, and Judge Massey found, based on the evidence, it was medically necessary. But the legislature has within its province to exclude certain types of treatment, even if they are medically necessary and even if they're not illegal. For instance, chiropractic care. The legislature has deemed it appropriate to indicate that more than 24 sessions of chiropractic care is not medically necessary, even if the doctor says it's medically necessary. Even if the doctor says just one more, 25 will do it for this claimant, an employer carrier would not be required to provide that
But
as
would
medically
the
necessary.
evaluation be appropriate? Would the evaluation be covered in that case?
No, Your Honor, and I wanted to get to that point, Judge Ray, because it's an important one. What would be the point in this particular case from a mootness standpoint, if I may start there? Mr. Jones has already had the evaluation. He has gone to a qualified doctor. He has submitted to the evaluation. He has been deemed to have a qualifying condition. He has been deemed to be a qualified patient. He has been entered into the registry as a qualified and is eligible to receive his certification card to obtain medical marijuana. It's done. What is the point of now requiring another authorization evaluation to reach that same conclusion potentially?
I may be able to help you a little bit because I want to ask you specifically, and this goes back to the referral statute and the limitations on referrals, and this is 440.13.3i, and that the referral is required unless the JCC determines that the procedure is not medically necessary or the treatment is otherwise not compensable under this chapter. So for instance, in your hypothetical with the 25th chiropractic visit, that would not be compensable under the chapter, correct?
That is correct.
Right, so if there's a treatment or prescription that's not available as a matter of law, then under the referral statute itself, it would not be compensable.
I would agree with you, Your Honor. That is a good point. In furtherance of that point, again, coming back to Judge Ray's earlier comment regarding, and yours, Judge Rowe, about the ultimate medical benefit. In this case, what would be the point of requiring an evaluation for a form of treatment that is not compensable? It is not compensable under Chapter 440, clearly as defined both in Section 381.986 as well as in the constitutional amendment. So it would be a futile exercise to require the employer carrier to authorize yet another evaluation to determine whether Mr. Jones is a candidate for a form of treatment that he will not be able to receive under Chapter 440, at least not from this employer, because it does remain illegal under federal law. So it would, again, Your Honors, be simply an exercise in futility to require Grace Healthcare to fund the evaluation when ultimately, if Mr. Jones is again deemed to be a candidate, as he surely will be since he's already in the medical registry, to then reach the conclusion that you're in the registry, you're eligible for this medical marijuana, but we're not required to pay for it, and we won't pay for it. And the judge of compensation claims, as indicated by Judge Massey, I think would ultimately conclude that it's not compensable because the law is clear that because it remains a Schedule I drug, it is illegal under federal law, it remains illegal, or at least not compensable under Chapter 440.
Except to get there, specifically with respect to the evaluation, we're not talking about the marijuana, we're talking about the evaluation, which even under 381.986 subsection 4, it is an actual medical evaluation. The doctor has to evaluate the patient in person has to reach some medical conclusions before certifying that patient to the registry. To get to the part where it's not compensable, don't you have to address the question whether it's medically necessary as defined in the statute? And a follow-up question to that second part of the question is it your position that it is medically necessary, this evaluation, under the statutory definition?
Your Honor, again, referring back to Judge Rowe's comment, it may well be that because it is not deemed medically useful under federal law, then that would translate into it being not medically necessary under Chapter 440. But again, Judge Tannenbaum, if I'm missing your point, I still would argue that even the evaluation is not compensable under Florida law.
But is it medically necessary under the statutory definition?
The evaluation?
Compensability and whether it's medically necessary, I think, are two different things.
Your Honor, I would submit to you that it doesn't matter whether it is or it isn't medically necessary because it is not reimbursable under Chapter 440. Just like the 25th chiropractic visit wouldn't be reimbursable because it's specifically defined to be not medically necessary under Chapter 440. But other forms of care, such as experimental care, are also not compensable. They might be medically necessary, they might be medically appropriate for a given claimant, but it doesn't make them compensable or reimbursable or that an employer could be required to furnish that experimental treatment.
Except if it's experimental, doesn't it come out of the definition of medically necessary in the statute?
I think it arguably would, as would chiropractic care, Your Honor, but I think the analysis is still the same. Again, if ultimately the care that the evaluation would lead to is illegal, then it would not be, or at least not reimbursable. The evaluation leading to that conclusion should likewise not be reimbursable. Again, I go back to the original argument, though, that the evaluation itself, Your Honors, would be in violation of federal law because the two are so inextricably tied. You cannot have medical marijuana or be deemed a candidate for medical marijuana without that prerequisite evaluation. And that is what ultimately, as framed on appeal, the claimant was seeking below, the evaluation. As Your Honor pointed out, Judge Ray, it's already been done anyway, so it's a moot point. And even one step further than that, the fact that it ultimately would lead to the employer carrier being requested to provide an illegal substance under federal law, what's the point of requiring the employer to even provide an evaluation?
But the question would matter, my question would matter, if, let's say, your reliance on whether the evaluation, your reliance on the argument that the evaluation itself is a violation of federal law, so it's not compensable, and your argument that the evaluation itself fits somehow in the definition of marijuana, if neither of those arguments carry the day, wouldn't my question about whether it's medically necessary in the first place be important to your argument?
You're saying that if an evaluation doesn't fit under the terminology of marijuana in Section 381.986,
Sure.
and it is not covered by the
And the
Constitution?
evaluation itself is not actually a violation of 21 U.S.C. 841 and 851.
Okay, and the question is, would it matter whether it's medically necessary?
My question to you was, is the evaluation that was requested medically necessary as that term is defined in the statute? And you said, well, it doesn't really matter because, and you have these other arguments, because it's not otherwise compensable and because the evaluation itself fits within the prohibition. Put those aside for a second. The question remains, is it medically necessary? Is your position, yes, the evaluation fits the definition of medically necessary in Chapter 440, and you're hanging your hat on these other arguments?
Your Honor, I'm not hanging my hat only on those other arguments because, again, I believe, as Judge Rowe pointed out earlier, that it would not be deemed medically necessary if federal law indicates that it is not medically useful and it is not medically necessary under federal law. I think it would make a difference in that particular instance. But we do have Section 381.986. Evaluation is included under that as being not covered by workers' compensation.
Well,
Eve-
yeah, and excuse me, I didn't mean to interrupt. So let me back up. So let's get out of the drug situation for a second and think about this a different way. What if you have a claimant with a back injury and the doctor refers them to an orthodontist for braces, right? And, there's no dispute, kind of like here where the employer doesn't really put up an argument. What happens then? Is the referral to the orthodontist, is that compensable even though there's no way braces would be compensable for a back injury? At least not that I know of.
That's a good point. It might be medically necessary to correct whatever dental or orthodontic problems the person had, but it wouldn't be causally related and medically necessary for the compensable back condition. I hope that answers your question.
Well, maybe, and perhaps it does, but I'm not with you yet. So let me give another example. So there's a claimant with a knee injury, and through the course of treatment, something's wrong with the elbow. So there's a referral to someone that can deal with elbows. Would that evaluation be compensable if at the end of the day it turns out that there was no treatment was needed for the elbow?
Your Honor, it could be. It's difficult to speculate without knowing all the details and facts of a case like that. I mean, ultimately, if it was diagnostic in nature or to assess whether there was any problem with the elbow causally related to the accident. Now, if the elbow is in no way causally related to the accident, it doesn't matter whether it's medically necessary or not. It wouldn't be compensable under Chapter 440.
And the employer could deny the authorization for the referral?
Absolutely. If it's not a compensable condition, just like the orthodontic or the whatever sort of orthodontic problem a person has, it doesn't have anything to do with the accident, it hasn't been deemed compensable, then a referral for an evaluation of a completely unrelated body part would not be medically necessary and would not be covered, at least at the employer carer's expense. And Your Honor, this is the point that I would like to make. This is not a situation that Mr. Jones or other citizens of this state cannot obtain medical marijuana. They can. What they can't do is request an employer or insist that an employer or a carrier pay for it. They have the constitutional right to access to medical marijuana now under certain prescribed conditions. And if they meet those conditions and they're willing to pay for it, any citizen of this state that's a qualified patient with a qualified condition that has the certification card can obtain medical marijuana at his or her own expense. Your Honor, we would, I see that my time is nearly up, but if I could just briefly conclude by again asking the court to affirm Judge Massey's decision that even an evaluation to assess Mr. Jones's candidacy for medical marijuana should be affirmed by this court. Thank you very much and for inviting us here today.
Thank you.
Hello again. Okay, so I just briefly want to address most recently that what you noted about the orthodontic or the elbow issue. And what was missed in that discussion was causation, right? So yes, it may be medically necessary, but there has to be the major contributing cause, right? So we have to prove, the claimant has to prove causation. Here, it was proved. It was reasonable, medically necessary, and the major contributing cause of the claimant's need for an evaluation with a qualified physician was the industrial accident. And so in those situations with the orthodontist, if the employer carrier, like they did in this case, shows up and doesn't present evidence, yes, the judge can deny unrefuted evidence or undisputed evidence, but they have to come up with a reason to substantiate it for this court if it ever were to be appealed. In this case, the judge went through the analysis, a fairly detailed analysis, as to why it is causally related to the industrial accident, why Mr. Jones, with a chronic intractable low back pain condition, who has one kidney, who's HIV positive, who has several situations where medical marijuana would be a better health decision for him to be able to make. It's about education. It's about Mr. Jones, the injured worker, being able to decide, have that right to determine, do I want to pay for the medical marijuana myself because I'm allowed through my constitutional amendment to get it? but I need a qualified evaluation with a physician, and it's causally related to my industrial accident. So if it's causally related to an industrial accident, the claimant should be able to make that decision. And the employer carrier should be able to make that decision too. The amount of money that they spend on opioids, the amount of money that are spent on Mr. Jones's case on a monthly basis, that he goes to Dr. Hunkalata, gets 3 separate prescriptions for these pills that are controlled substances under their Schedule 2,
Schedule 2.
right? So the employer carrier should have that right to be educated and make that decision. Do they want to pay the $200 evaluation for a physician if the claimant decides that he just wants to get the medical marijuana himself?
Do you agree, though, that the record indicates, according to the treating physician, that the employee was taking the pain meds as indicated, at least most of the time? I guess he had some transportation issues, but the pain meds were working. They were doing what they were supposed to be doing.
They were helping alleviate his symptoms, yes, but he was having side effects. He was
Sure.
having to do the blood work constantly. There's always the question of long-term effects. He's been using them for 19 years.
Right.
Right.
And his existing doctor, the treating physician, he has the power to prescribe other meds and explore other Schedule 2 substances that may work better, or maybe there's alternative treatments that involve medications as well. But he did not explore that. He provided a referral specifically for one purpose alone.
Well,
And what was that purpose?
it was for medical marijuana that is legal through the constitutional
Sure.
amendment.
But the evaluation, this goes back to what you were saying in your primary argument.
Yeah.
The referral wasn't to see if there were other options, other treatments besides marijuana. It was specifically so that he could potentially get on the registry. Do you agree with that?
Your Honor, this case has been going on for 19 years. So the claimant has been treating with Dr. Hunkalata for a significant other options had been explored. I mean, that's not in the record because that's not the issue before this court. The issue before this court is whether an authorization of an evaluation with a qualified physician is appropriate, is reasonable, medically necessary, causally related. All that's already been answered. It's a question of law as to whether the claimant should get that evaluation. It is not defined as marijuana. An evaluation is not marijuana under 381.985, right? That's not marijuana as the way the description in the statute is.
But you agree that it is a question of law whether the evaluation was medically necessary?
Not medically necessary, whether the evaluation should have been authorized by the employer carrier. The medically necessary part is a question of fact that was already determined by the judge of compensation claims and not disputed by the employer carrier. They didn't dispute it. They didn't dispute that it was causally related, although they threw these defenses out on the pretrial. It wasn't mentioned. And just briefly, I know that I don't have much time, but just when this court asked whether the CSA, the Controlled Substance Act, is preempted by the state law, and I think that it's already been determined, but it's specifically outlined in this New Jersey decision. And it talks about Congress has expressed an intent in the plain language of the CSA that it only preempts the state law that requires the performance of an action specifically forbidden by the federal statute. An evaluation with a qualified physician is not a specifically preempted or forbidden act by the federal statute under the Controlled Substance Act. So, Your Honor, I would ask that this court reverse the judge of compensation claims final order from April 2019.
Thank you.
Thank
Thank you to both attorneys. We appreciate the excellent presentations. The court is now adjourned.